The fires were lit before dawn, not after. Before. The kitchen staff at Hampton Court began their work in the dark hours before sunrise, the same way they began it every other morning, moving through cold stone corridors with tapers, relighting the great hearths, setting water to boil, beginning the first preparations of a day that would require feeding several hundred people at their appointed hours, regardless of what had happened the previous morning. This is where the story begins. Not at the scaffold, not at the moment the sword moved, or the axe fell, or the crowd went quiet. Here, in the kitchen, in the dark, in the ordinary sounds of an institution resuming its functions with the thoroughness of something that had never considered stopping. It is the most disturbing detail in the entire history of Henry VIII's court. Not the executions, the morning after. Hampton Court in the Tudor period housed between 500 and 800 people on any given day. Servants, officials, courtiers, guards, chaplains, musicians, physicians, stable hands, laundresses, cooks, pages, ladies-in-waiting, gentlemen of the chamber. A small city organized around the single purpose of keeping the king comfortable and the institution functioning. That institution had one defining characteristic that distinguished it from every other kind of human organization. It did not stop, not for grief, not for shock, not for the specific moral vertigo of continuing to function the morning after someone you knew had been publicly killed at the king's order. The institution required its fires lit, and its breakfasts prepared, and its horses fed, and its chapel bells rung at the appointed hour, and its council meetings convened, and its correspondence managed, and its floors swept. And it received these requirements without negotiation, without acknowledgement of what had happened the day before, without any formal recognition that the morning was different from any other morning. Because formally, it was not. The person who had been executed was gone. That was the legal and administrative fact of the matter. What Tudor administration required next was not mourning or reflection, or the specific human pause that follows violent loss. What it required was reassignment. The executed person's servants needed new positions. Their chambers needed new occupants. Their seat at whatever table they had occupied needed either to remain empty, which communicated something, or to be filled, which communicated something else. Their correspondence needed to be seized and examined. Their personal effects needed to be inventoried. Their name needed to be removed from the documents where it appeared in ways that were no longer accurate. All of this happened with the specific efficiency of a system that had done it before and expected to do it again. The speed is what requires attention, not days, hours. The reassignment of servants began within hours of an execution because servants without positions were a practical problem. They needed feeding, housing, direction. The chambers were assessed within the same day because chambers were a resource, and resources in a palace of 800 people were never surplus. The correspondence was seized immediately because correspondence was evidence, and evidence required management. The institution did not pause to feel what had happened. It processed what had happened, and the processing looked, from the outside, almost identical to the ordinary administration of any other day. If this changes how you see history, subscribe to Unknown Chronicles. We find the rooms, history locked. The breakfast hour at Hampton Court arrived at the same time it always arrived. The great hall was set, trestles arranged, bread brought from the bakehouse. The hierarchy of Tudor dining, who ate where, who ate what, who waited on whom, observed with the same precision it was observed every other morning. The people who filed in and took their places did so with the practiced movements of people who had performed this ritual hundreds of times and whose bodies knew where to go without requiring instruction from their minds. What was different was the silence in certain places, not everywhere. The Great Hall was not a silent room. It never was. Several hundred people eating at long tables in an enclosed stone space produce a constant ambient noise that fills the architecture regardless of what anyone is feeling. But within that noise, in specific locations, In the conversations between specific people, there were gaps, sentences that changed direction before they reached a name, questions that stopped arriving at their natural conclusions. A conversation about the weather that should have lasted 30 seconds lasting 3 minutes because nobody wanted to be the first person to stop talking about the weather. The name of the executed person was not spoken at breakfast. Not because anyone had forbidden it. Nobody needed to forbid it. The understanding was atmospheric. It existed in the room the way temperature exists in a room. Not announced, not explained, simply present in a way that everyone felt and nobody described. The seat nearest the king remained empty. It had been empty at previous meals too, when the person who normally occupied it was absent for other reasons. But those absences had a quality of temporary to them, a quality of will return that shaped how the empty seat was perceived. This absence had a different quality. The people sitting near it registered the difference with their bodies rather than their thoughts. A slight adjustment of posture, a tendency to look slightly away from that section of the table rather than toward it. Nobody said anything about the seat. Nobody moved to fill it. By the following week, someone would be sitting there. That was the arithmetic of court life, the way vacancy and ambition combined to fill spaces that opened in the hierarchy. But on this morning, the seat stayed empty, and the adjustment of posture around it was the only acknowledgement available. The chapel bells rang at the appointed hour. Morning prayer proceeded as it always proceeded. The chaplains in their robes, the congregation in their places, the liturgy moving through its appointed sequence with the specific comfort of words that had been arranged in this order for long enough that they required no thought to follow. Only presence, the body carrying the ritual while the mind was elsewhere. What the mind did with elsewhere on this particular morning is not in any record. Tudor people did not write about the specific psychological experience of attending morning prayer the day after a colleague's execution. They wrote about the prayer itself, the attendance, the proper observance of religious duty. The inner experience, the specific work of sitting in a chapel performing devotion while whatever they were actually feeling occupied a different and unacknowledged part of their attention. That work was private, and it stayed private. What is in the record is attendance. Who was present? Who was absent? The absences on the morning after an execution were noted because absences at court were always noted, not out of pastoral concern, but out of the specific administrative interest of an institution that understood absence as information. Someone who did not appear at morning prayer was communicating something, whether they meant to communicate it or not. Most people appeared. Most people sat in their places and followed the liturgy and stood and knelt at the appointed moments and filed out at the appointed time and moved on to the next obligation that the court day required of them. Not because they felt nothing, because feeling nothing and continuing were, in the Tudor court, functionally identical from the outside. And the outside was all that mattered. The council met that morning. This is perhaps the detail that most rewards attention. The Privy Council, the men responsible for governing England, many of whom had been directly involved in building the case against the person executed the previous day, signing the documents, providing the testimony, attending the trial, convened at their appointed hour, in their appointed chamber, around their appointed table, to conduct the appointed business of the kingdom. The chair that had belonged to the executed person, if they had been a councillor, was present. Chairs do not remove themselves. Someone had to decide whether to remove it or leave it, and the decision that was made on this particular morning was to leave it, because removing it would have required an acknowledgement that removing it was a decision that needed to be made, and making that acknowledgement would have introduced into the chamber a conversation that nobody in the chamber wanted to have. So the chair remained, empty, present, communicating its emptiness to everyone in the room without anyone being required to address it. The council discussed what the council always discussed: correspondence from foreign courts, financial matters, administrative questions requiring royal approval, the business of governing a kingdom that continued to require governing regardless of what had happened on Tower Green the previous morning. Subscribe so you never miss a story like this one. The king was present, or absent, depending on the execution, depending on who had been removed and why, and what the removal had cost him emotionally. Henry VIII's presence or absence at the council meeting the following morning communicated volumes that nobody was permitted to interpret aloud. When he was present, he was the king. When he was absent, he was a man processing something in private that could not be processed in public. Either way, the council met. Either way, the business was conducted. Either way, the institution continued. The person's rooms were being assessed by mid-morning. Not emptied? Not yet. Assessed. An inventory official moving through the chambers with a clerk, noting what was present, recording the contents with the specific neutrality of someone for whom this was a professional task rather than an experience. Furniture, hangings, books, clothing. Personal objects whose ownership now required legal clarification. The process was thorough, and it was quiet, and it was conducted with the same procedural precision that Tudor administration brought to every other form of record-keeping. The clothing presented its own specific challenge. Tudor clothing was expensive, extraordinarily expensive by the standards of the period, often representing months or years of income for the person who owned it. It did not simply disappear because its owner had. It required disposition. Some items would revert to the crown. Some would go to specific individuals named in whatever arrangements the executed person had made. Some would be claimed by creditors. The process of sorting this out began immediately because delay created complications, and Tudor administration disliked complications. The personal objects were more difficult. Letters, books with annotations in the margins, objects whose value was sentimental rather than monetary, and whose sentimentality now presented a problem, because sentiment for an executed traitor was itself a kind of political statement, and political statements in Tudor England required management. The clerk noted what was present. What happened to certain objects after the notation is sometimes in the record and sometimes not. What is consistent across multiple executions is the speed, the assessment completed within days, the chambers available for reassignment within weeks, the new occupants' belongings appearing in corridors that had contained different belongings a month before. The space absorbed the change. Spaces always do. By afternoon, the court had resumed its full rhythm. This is the detail that requires the most sustained attention, because it is simultaneously the most ordinary and the most disturbing thing about Tudor court life. By afternoon, not the following week, not after a period of formal mourning, but by the same afternoon of the morning after, the full social machinery of the court was operating at its normal register. Music in the Great Hall, games in the Privy Chamber, conversation in the galleries, not subdued conversation, not the quiet murmur of people still processing the previous day, but the full volume social performance of courtiers doing what courtiers always did, which was manage their relationships with each other and with power, with the specific energy of people whose professional survival depended on appearing to be fine. Appearing to be fine was a skill. In the Tudor court, it was perhaps the primary skill, more important than any other form of competence, more valuable than intelligence or education or genuine ability. The person who could not appear to be fine after an execution was a liability. They communicated distress, which communicated sympathy, which communicated potential disloyalty. Distress was information, and information in the Tudor court was always being read by someone. So people appeared to be fine. They played cards. They made conversation. They attended the entertainments that the court scheduled, because the court always scheduled entertainments, and the entertainments always proceeded, because proceeding was what entertainments did. They laughed at things that were funny, and made appropriate expressions at things that were not, and maintained the surface of court life, with the collective effort of several hundred people who understood, without anyone explaining it to them, that the surface was the only thing standing between all of them and what had happened to the person who was no longer there. The name began disappearing from documents within days. Not all documents. That would have been administratively impossible and legally complicated. But the working documents of the court, the correspondence, the records that required ongoing maintenance, in these, the name began to be absent in ways that were not quite removal and not quite presence. References that had been natural became awkward. Awkward references were avoided. Avoided references left gaps. Gaps became the new normal. Within a month, the name was spoken rarely. Within 6 months, it appeared in conversation only when directly relevant to specific matters that could not be addressed without it. Within a year, it had acquired the specific quality of something that everyone knew and nobody said. Present in the room the way the empty seat had been present, communicating its weight through the specific effort required to not address it. This was not policy. There was no formal instruction to stop saying the name. There was no edict requiring forgetfulness. The forgetting was organic, produced by the same collective intelligence that had produced the silence at breakfast, the avoided eye contact in the corridors, the conversation that changed direction before reaching its natural conclusion. The court knew what was safe to remember and what was dangerous to say. It had learned this the way it learned everything, by watching what happened to the people who got it wrong. The children, if there were children, were the most complicated part of what the morning after required. The executed person's family did not disappear with them. Their children remained. Their siblings remained. Their parents, if living, remained. The complicated geometry of Tudor family loyalty, which required demonstrating that your attachment to a convicted traitor had not contaminated your own loyalty to the crown, played out in the weeks and months after an execution with the specific anxiety of people navigating a situation for which there was no established protocol beyond survival. The children of executed traitors occupied a legal and social position that Tudor England had not fully resolved. Their parents' attainder, the legal instrument of conviction, affected their inheritance, their title, their status. But it did not remove them from existence. They continued to be present in the world, requiring feeding and housing and education and eventually position, in a court that had just destroyed the person most responsible for providing those things. Some were taken in by relatives who were willing to absorb the political risk. Some were placed in households where their presence was managed carefully enough that they caused no problems. Some disappeared from the record entirely. Not because anything happened to them, but because the record stopped finding them worth noting, which in Tudor England was its own kind of disappearance. They grew up in a world that had processed their parents' death with the same efficiency it processed everything else. They learned the names they could say, and the names they could not. They learned the specific performance of normality that the court required. They learned it the way everyone in the Tudor court learned everything, by watching and surviving and continuing. By the following week, the chamber had a new occupant. The timing varied, sometimes faster, sometimes a few weeks slower, depending on the specific circumstances and the specific person whose rooms were being reassigned. But the direction never varied. The rooms were needed. The court was full of people who needed rooms. The arithmetic of institution always produced the same outcome. The new occupant's belongings appeared in the corridor first. Boxes, trunks, the physical evidence of a life preparing to relocate into a space that had recently contained a different life. Servants moved things in. Servants moved things out. The transition was managed with the same invisible efficiency that managed everything else, so that by the time the new occupant slept in the room for the first time, the room contained nothing that had belonged to the previous occupant and communicated nothing about the person who had been there before. The fresh rushes on the floor covered the old footprints. The new candles replaced the burned-down stubs. The hangings, if changed, were changed to the new occupant's taste. If not changed, they remained, carrying no visible record of the person who had chosen them and who would not be returning. The palace absorbed it. Palaces always do. The institution that had been functioning since before any of its current occupants arrived would continue functioning after all of them were gone. It had processed arrivals and departures of every kind: births, deaths, marriages, executions, natural ends, violent ones, And it would process more. Its fires would be lit before dawn tomorrow, the same way they had been lit before dawn today. Its kitchen would begin its preparations in the dark. Its chapel bells would ring at the appointed hour. Someone new would be sitting in the empty seat by next week. And the conversation would continue moving carefully around the name of the person who had been sitting there before. Not because anyone had forbidden it, not because anyone had instructed the forgetting, but because the court had learned, over 40 years of Henry VIII's reign, exactly what remembering the wrong things cost. The fresh rushes covered the footprints. The fires were already lit for the morning. And nobody said a word about why the room smelled differently. If this story reached you, subscribe to Unknown Chronicles. New documentary every week. There are more locked rooms in this history. We will keep finding them. How long do you think you would have lasted in that court? Leave it in the comments. We read everyone.